interim order to continue till the date. Yes, my lord. Obliged, my lord.
My lord, item number 1 and item number 1, item number 1, part 1, my lord. Part 1.
Ano po lang? Ay, uncalled po to.
No, my lord, we would like to mention, since the land AG is on leave,
I can
Which part?
part 2, my lord.
Part 2.
Part 2, item number 8. Part 2, number 8.
Number 8.
My lord, I seek your lordship indulgence in mentioning part 2, item number 8. Yes, my lord. As agreed upon by both the parties, I pray this matter to be taken up upcoming after 3 weeks, if possible. No, but a petitioner, my lord.
Additional AG is here.
Yes, Your Lordship. I have no objection.
After 3 weeks, you want?
Yes, my lord.
Part 1, item number 1.
Yes.
My lord, item number 1, for this, we would like to seek 3 weeks time for hearing. We have obtained the consent of the respondents.
No, otherwise, you are for the petitioner or you are for
I am for the petitioner, my
the
lord.
petitioner.
Yes, my lord.
For the, this case is otherwise ready for hearing.
Yes, my lord.
So you want time.
I want time, my lord. For 3 weeks time, if possible, my lord.
You are for the respondent,
I am appearing on behalf of Miss Mary.
Miss Mary. Miss Mary is appealing for respondent number
3 and 5.
You are Mr.
Nichunga dalong, my lord.
Miss Mary. For the respondent number 3 and 5. Mr. Secretary, we need 3 weeks more? 3 weeks.
Yes, my
After
lord.
3 weeks, 3 weeks. You want any fixed date or no?
If possible, my lord.
If possible.
Yes.
23rd of April.
Obliged, my lord.
Item number 2.
My lord, item number 2 is returned from the national mediation. Then I may be given 3 weeks time for filing my affidavit, my lord.
You have already filed?
Not yet filed. Oh, for filing, my lord. I am seeking time for filing.
Work for the petitioner?
I am for respondent number 2 and 3. The state already filed, my lord. Okay.
You are for the respondent 1 state 1 to 6.
Yes, 1 and 6 is state.
Sorry, 1 to
I am for respondent number 2 and 3.
Lordship, I am appearing on behalf of state respondents number 1 to 4 and we have already filed. 1 to 4.
That's it.
1 and 4.
Tani and Dujana and Tay, okay?
And here's the hand on right.
1 to 4, 1 and 4. I can't fit.
what had happened? The matter was already earlier referred to mediation also.
My lord, even I received my drafted affidavit in return. However, there is incorrect of the justice name. That is why we have to send it back.
No. as per order dated 10/2/2026, there's an order that matter may be referred to mediation also.
They already referred to mediation, then it's returned back here.
It's it returned back.
Mediation failed, my lord.
Pardon?
Mediation failed, lordship.
Mediation failed.
Lordship, yes.
Okay.
Lordship is the item number 2.
Yeah, in item number 2.
Yes.
So now you need 3 weeks time for your submission. You are Mr. Chakma, I think, no? Yes. Hard Mr. B. Chak. Pardon? Yes. Yes. Hard Mr. B. Chakma, the learned counsel for the petitioner, also heard. So you are for the respond number for 2 and 3. Yes, you are for the petition. So and so matter is listed for admission, but however, MS Namsu syllabus, so and so the learned additional easy appearing for the respond number 2 and 3 submitted that he need. You are for the 4 and 5. 1 and 4. Number 1 and 4. Full stop. Mr. Chakma, the learned counsel for the petitioner, raised objection and submitted that the matter is pending since 2022, but till that the respondents state affidavit in opposition. Considering this aspect of the case, the state respondents are hereby directed to file their affidavit in opposition within 3 weeks' time, and so that the matter can be proceeded further. List the matter. Yeah, we are listing it after 3 weeks' time. Within 3 weeks, you file your affidavit in opposition. Let the matter accordingly be listed after 3 weeks as the 2 weeks may be raised. Okay.
Item number 3. May it please your Lordship, the pleadings are complete. If this matter may kindly be fixed for admission hearing on the 21st of next month, just after the vacation.
Yes, state respondent, do you have any objection?
Before the vacation. Before the vacation. At the end. So, 27th, I mean, 27th? 27th, your April 27th.
27th April.
Yes.
With the consent of the state respondents, the learned counsel for the petition, Mr. Malhotra, submitted that we have paid for an adjournment to which the state respondents raised no objection. List the matter accordingly on 27th of April, so and so in admission.
For admission hearing.
Pardon?
For admission hearing.
Yes, for admission. I'm listing it on 27th of April.
Item number 4. Sorry?
We have received it this year.
Yeah.
May I please, Your Lordship? Lordship, as per the last court's order, we have furnished the appeal memo to the sole respondents. So if the matter can be kindly taken up after vacation for disposal.
No, service is already completed.
Yes, Lordship.
So you are appealing for the respondent. So then?
If the matter can be kindly taken up after vacation for disposal, Your Lordship. Disposal of the appeal at the admission stage. Admission hearing, Your Lordship. Your Lordship, both the leading counsel.
Or what?
Yes, Lordship. Both the leading counsels are not.
Leading counsel.
Yes,
Who is
Lordship.
your leading counsel?
Mr. El Fakoma.
heard MS so the learning counsel for the appellant, and also heard your MS. You don't have any objection. Ms. Rosie Namtodias so and so, appearing for the sole respondent. MS so and so, the learning counsel appearing for the leading counsel, Mr. L. Lacoma, submitted that he is not in a position to appear before the court today for proceed with the hearing. Accordingly, she paid for an adjournment, to which the learned counsel appearing for the respondent did not. The original TCR has already been received. The matter will be accordingly listed in addition column. Yes, any date you want?
Date fix now.
Any date? Want to date fixed?
21st of April.
Give me a blush.
21st of April.
Yes, Lordship.
Item number 5.
May it please your lordship,
See,
I'm here for the appellant, and my lord, notice was issued by way of dusty mode, and after a thought.
so what happened? Dusty mode was last time. Dusty mode was allowed. Then you have already filed. One, two, and three, they have already appeared. Yes.
Let them show in for the respondent number 1 and 3. And my lord, if we may be given another 2 weeks time to file a written objection to the IA. Yes, my lord. Yes, my lord. One English and one without.
number 6.
Your Lordship. This bail application is filed under Section 483 of the BNSS, read with Section 37 of the NDLPS Act, my lord. So, my lords, the brief facts of the case is that the petitioner, along with two other co-accused, were arrested in connection with the seizure of 1.972 kgs of methamphetamine. So, here in Aizawl. And then the charge sheet was already filed and the trial is going on. And then the bail application was filed before the trial court and it was rejected on 14th of January 2026. So, my lords, the present petitioner herein sought for release him on bail only on two grounds. There are two issues involved in this case. So, the first one is, my lords, that notice under Section 47 was issued, but the present petitioner is from outside Mizoram. So it was written in English, so which is not in consonance with the Honorable Apex Court judgment in Mihir Rajesa. So as per the Honorable Supreme Court judgment, the notice in writing has to be communicated to the accused in the language known to him or her. So which is not, that is the first one, my lord. So, and the second one is, there is no notice issued under Section 48 of the BNSS to the relative of the accused or the near friends. So, my lords, it was merely mentioned that in the arrest memo, family and friends were communicated, but the specific person whom they have contacted were not mentioned. The names is not there. So, that is my grounds, my lords. So, in that regard, my lords, if I may kindly take your lordship to page 20 of the application.
Yes.
My lords, that is the notice under Section 47.
Yes.
Plus, in this notice, it was written in English, so that there is nothing on record to show that the present petitioner accused do understand English. So, and then even in this notice also, there is no mention of section, the section for which he was arrested. It is not mentioned anywhere, my lords. And that is my grounds, my lords. So, my lords, if I may kindly submit the judgments to support my submission, my lords. There are three judgments. One is your lordship judgment in principal bench, my lords. My lords, the first one is Mihir Rajesa versus State of Maharashtra and others, 2025 Life Law SC, page 1066. And my lords, the operative portion is at paragraph 56.
Yes.
If I may read, lordship. Para 56, in conclusion, it is held that 1. The constitutional mandate of informing the arrestee the grounds of arrest is mandatory in all offences under all statutes, including offences under IPC 1860, now BNSS 2023. 2. The grounds of arrest must be communicated in writing to the arrestee in the language he understands. I will stop here, my lords. This is what I have raised in this regard, my lords. And my lords, the second one is Gurmel Singh. That is bail application number 1229 of 2025. This is your lordship judgment. My lords, if I may kindly take your lordship to para 21, which is at page number 10. in the second part of the judgment of Bihan Kumar Supra, it is also being observed by the Honorable Apex Court that the purpose of inserting Section 50A of the CRPC, making it obligatory on the person making arrest to inform about the arrestee to the friends, relatives, or persons nominated by the arrested person, it to ensure that they would be able to take immediate and prompt actions to secure the release of the arrested persons as permissible under the law. The arrested person, because of his detention, may not have immediate and easy access to the legal process for securing his release, which would otherwise be available to the friends, relatives, and such nominated persons by way of engaging lawyers, briefing them to secure release of the detained person on the bail at the earliest. And my lords, the third one is the a coordinate bench of this court judgment in bail application number 4109 of 2025. And my lord, operative parties paragraph 6 and 7, my lords. If I may read. Paragraph 6E, a perusal of the notices under Section 48 available in the scan TCR could go to show that they were prepared in the English language and sent to the relatives of the petitioners by way of WhatsApp messages, but there is no proof of service available. Para 7, in the absence of actual service, it certainly cannot be held that there was due compliance with the provisions of Section 48 BNSS as per the mandate of the Apex Court in Bihan Kumar versus State of Haryana and other, reported in 2025 SCC online SC269. So, my lords, these two grounds are my submission. So, and I humbly pray your lordship to.
Where from you're saying that 48 was then where? 48?
Sorry, my lords.
You're saying that there's an intimation to the family members. Where? In which
No, no notice was sent. In the arrest memo, my lords, it was
he
merely
got arrested in which place?
Aizol.
Pardon? H?
Aizol.
Aizawl.
Yes.
And
the-
place of residence is?
Place of residence is, my lords, Tripura.
So can you expect that from a person from Tripura will be immediately intimated if he
Yes.
got arrested in Aizawl?
So, my lords,
There
they.
has to be something, either maybe WhatsApp, through messages, through the Tripura police station or the Tripura police station, then only it can be communicated to the family members or friends. Otherwise, a person from Tripura who got arrested in Aizawl. So
Manoj,
immediately, yes.
In the arrest memo, my lords, if I may,
Yes, arrest memo is there.
if I may kindly take your lordship to page 16.
Page 16.
16, yes, my lords. That is the arrest memo. So, in the first paragraph, my lords, it was merely mentioned that relatives were also contacted and informed about their detention. So, my lords, who is the
Wait,
page 16, my lords, first paragraph. So,
that is there in your arrest memo.
arrest memo. Yes. But my lords, if there is any contact, so their phone numbers, at least it has to be reflected.
4 numbers, please.
Phone number of the relative.
numbers.
Yes, yes.
Yes. Okay.
So I humbly pray your lordship.
So what is the state of the case? In the state is evidence.
My lords, no, my lords. I think I am not the counsel in the trial court, my lords. So I don't know what about the evidences.
No, I'm asking your charge sheet is filed.
Yes.
Charge is already framed. Or
Yes. I think 3 witnesses have been examined till date. Out of 12 witnesses, 3 witnesses have been examined.
3 witnesses have been examined.
Yes, my lords.
Out of 12.
Out of 12.
And this, what I mean to say, he got arrested when?
24/7/2025.
24/7.
2025.
He got arrested. Okay. Yes. Any other submission?
No, my lords. That is my humble submission, my lords.
Yes.
Your Lordship, with regard to the first ground which my learned friend has raised, that the grounds of arrest was given in English. Your Lordship will turn to page 20 of the petition, my lord. Page 20 is the notice under section 47(1)(2) of BNSS 2023. This is the grounds of arrest. It's written down in English, no doubt about it. But my lord, your lordship will see at the bottom, right-hand side, bottom, Halaluddin. And he has given his signature in English. So there is no doubt that he understands the language. And as to the second point, which my learned friend has raised, my lord, like he has stated, my lord, at page 16, the families were intimated. And I'll say that, my lord, the purpose is served. The purpose is to ensure that the families knows about the arrest so that they can take their time to make a release of the accused. And this intimation was given immediately on their arrest. So, my lord, my humble prayer is that since the purpose is served, my lord, there's no violation of any provisions of the NDPS. And since it's a commercial quantity and the petitioner is a resident of outside Mizoram, there's a great chance of him absconding. So my prayer is that let him be not released on bail since trial is going on at this stage.
Heard. You are Mr.
S. Mandalfriata.
Heard, Mr. S. Naam to likhi labo, Palantir and so, the learned counsel for the petitioner, and also heard MS Linda, the learned PP, State of Mizoram. To stop, this is an application under section so in connection with so. Scanned copy of the TCR has already been received. Where is TC? It is submitted by Mr. Walfom that the present accused petitioner is in custody since 24/7/2025 when he got arrested with the allegation of recovering methamphetamine tablets in commercial quantity. The case has already been charge sheeted, and presently the case is pending at the stage of at the trial stage. Out of 12 numbers of witnesses, 3 has already been examined. 3 has already been examined by the prosecution. He further submitted that there is no proper compliance of 47 BNSS, and as per any BNSS, which from as it is seen that he was given the arrest notice in English language, which he cannot understand, as the person belonged to Tripura and accept the said language. He is not in a position, he is not understand any other language, any English language, full stop. He further submitted that in case of Mihir Rajesh Shah, the Honorable Apex Court has held that the notice under section 47 BNSS should be communicated to the accused / arrestee in the language he understands. In that context, he basically relied on para 56 of the said judgment, 56 of the said judgment, which read as under 56 to 41. Accordingly, he also relied on 2 other decisions of this coordinate bench of this court, wherein also it has been observed that there is necessary for compliance of 47 BNSS post. Next para, Mr. So-and-so further submitted that there is no compliance of 48 BNSS also, as no notice was served to the family members or friends or relatives of the petitioner under section 48 BNSS. Post up in that context also, he relied on the decision of Honorable Apex Court passed in the case of Bihan Kumar, wherein it has been specifically observed that the notice under section 48 BNSS has to be served on the family members, friends and relatives so that they can arrange for legal procedure for his release. Full stop. Next para. Accordingly, Mr. So-and-so submitted that this is the considering this non-compliance of section non-compliance of section 47 and 48 BNSS, and also considering his length of incarceration, the accused may be released on bail. However, being the permanent resident of his address locality, he will appear and contest the case regularly as on date to be fixed by the learned trial court below. Next para. MS Linda, the learned PP, submitted in this regard that there was sufficient compliance of section 47 and 48 of BNSS. From the notice issued under section 47 BNSS, it reveals that the language is English, but from the below, but it is seen that the petitioner had put his signature in English language, which otherwise establishes that, who otherwise proved that he can understand the English language. More so, from the arrest memo, it is seen that the family members and the relatives were informed immediately after his arrest, and thus there is sufficient compliance of section 47 as well as 48 of BNSS. She's further submitted that the case is of commercial quantity and the accused person hails from Tripura, and hence there is every probability of absconding if he is released on bail at this stage. Accordingly, she raised objection and submitted that it is not at all a fit case to consider his bail application at this stage. Rest I'll give it in the chat. I'll recorded your submission. Rest part I'll give.
My lord, deeply obliged.
Item number 7.
You give me my chamber.
May it please your worship. In this matter, the appellant and the respondents have reached a amicable settlement outside the court, your worship. So the matter may be closed, or we may be allowed to withdraw with liberty to file afresh if so required. Otherwise, there's been a settlement outside of court.
Two aspects today. If you want to withdraw the case as because matter has already been settled or compromised, it's okay. But if you want to say that you want a liberty, in that case, so I don't know.
Then your worship may kindly reflect that since the matter has been amicably settled outside court, the appellant is allowed to withdraw the matter.
No, we'll write in that way. No, but I'm saying that if you want a liberty, that then matter would be a bit different in that case. That's what I'm saying.
Otherwise, your worship, it's settled.
It's okay. Otherwise, we can dispose of the matter.
Yes.
If it is already disposed of. I mean, if it is settled. It's an RFA, na?
Yes.
Yes, sir. What do you want to submit? Anything?
Lordship, if the case may be disposed of.
But if it is disposed of, suppose the question will be there that the order or judgment passed by the trial court will remain. So,
But then to be on the safe side, I may be allowed to withdraw it with liberty.
yes, what do you want to submit? If required, he will. Do you have any objection in that case?
No, I do not.
No. But the question is that what I'm saying, simple liberty without simple withdrawal without any liberty is okay, but withdrawal with liberty would mean otherwise. So, do you have do you want to raise any objection? If it requires only, then only he will file in that case.
Yes, in that case, my lord, if the matter be gone as withdraw and with no liberty to file.
There are with liberty, my friend. Report of the
My lord, as we have settled outside the court, it is
No, settlement
fine.
outside the court is okay.
Yes.
We are not on that.
It is
Because
also fine
as
if
soon as we
liberty
will dispose
is
of the
given to
matter on this, on matter of compromise only, we'll dispose of, or withdrawal will be allowed. In that case, the judgment of the trial court will remain there, because decree is most probably there or whatever. I have not gone through the entire record, but was there. Do it, if it is already settled, then on the basis of that settlement, you can approach the learned trial court below, also decree will be accordingly, otherwise. Because
Gotcha.
decree is there, most probably.
Let it come up next week.
Think of it. That's what.
My
Lord, we
learned
have
friend
no
is
objection.
senior is not here. That's why he's a bit hesitant. So let it come up next week. Let his senior be here.
Okay.
No, mind of Shella.
Think in that way,
Let it come up.
because everything is settled. Suppose then there may not be a question of, liberty may not be there, or if it is liberty also, it would not affect you. But it's just consult with your senior.
Yes, my lord.
Okay. Okay.
Anytime next week, yeah.
Heard Mr. A.R. Malhotra and also heard MS Linda for the respondent number 1 and Mr. Swenso for the other respondents. It is submitted by both the counsel for the appearing for both the parties. The matter has already been settled outside the court. However, submitted that it can be listed on the next week as the engaged counsel. Who is your engaged counsel?
For the respondent number 2.
Respondent
Mr.
number 2.
Bilaram.
Pardon?
Mr. Bilaram.
Acha.
Respondent number 2.
Number 2 is not available in the court today. Listed next week, any date? It
Any
can
date.
be
9th of April.
9th of April?
I'm obliged.
Oh, nice.
Item number 8. May I please your lordship?
Yes.
My lord, on the last occasion, the trial court records has been called for, and it appears that the report has arrived. So
Trial court record is there only, yes.
Yes, my lord. So the matter can be listed for
Service
hearing.
is also completed.
Yes, my lord. Duly represented by the respective counsel.
2 to 4 and 1 is represented by, who is represented?
Dylan Nsiama,
one
my
is-
lord. Respondent number 1.
You're for the 1
Yes, my lord.
and 2 to 4 you are representing.
Yes, Your Lordship.
2 to 4 is a state.
State.
State. Okay, if, the records are here and the appearance is, otherwise do you want any, otherwise it can be listed for admission column. Or for final hearings, yes.
Final hearing, my lord.
Final hearing. Let it be an admission column. If anything is there, then can be, or otherwise it can be heard and decided in admission column itself.
Since the matter has already been admitted, my lord, it can be listed
Oh,
for
admitted,
final
already
hearing.
admitted. Na?
Yes, my lord.
Okay. Heard Mr. Victor L. Redley, the learned counsel for the appellant. Also heard MS Bade Sehmiba, the learned additional AG for the respondent number 2 to 4. And also heard Mr.
Dylan Nsiama.
T. Lalam Sema, the learned counsel appearing for
On
the
behalf of
respondent
Dylan
number
Nsiama, my lord.
respondent number 1. This trial court record has already been received. Case is ready for hearing in the hearing. Accordingly, the registry is hereby directed to list the matter in hearing column. Want any preferable date is there? After 2 weeks?
After 2 weeks, ma'am.
2 weeks as on a date to be fixed by the registry. Okay, by listing it in hearing column after 2 weeks.
Deeply obliged. Item number 9.
Your Lordship, on behalf
What
of
is I about?
If may I, my lord,
Yes.
the state respondents have filed this IA seeking for extension of time for compliance with the judgment. But they have filed it belatedly, my lord. In a general practice, this type of extension for compliance has to be filed within the stipulated original time frame. The judgment order in this contempt petition is dated 17/3/2023, and the matter pertains to direction for regularization of the petitioners SSA teachers, my lord, within 6 months therefrom. Now this contempt petition was filed on 2023, and now we are in 2026, my lord. And so far as the affidavit available on record, my lord, the steps which has been taken by the state respondents reportedly was till November 2024. 2024.
Till 24.
Yes, my lord. After filing the affidavit or otherwise, my lord, they have not taken any further steps. So, my lord, this IA for extension for compliance cannot be permitted at this stage, my lord. And on the other hand, my lord, the state respondents have been making recruitment of school teachers in different capacity. In total disregard of this judgment order, which is a standing direction for consideration of the case of the petitioners, my lord. Now the petitioners, some of them were in the ripe age, some of them have now retired without enjoying the benefits of the judgment order, my lord. So this IA cannot be permitted, and the contempt has to be proceeded as it is. No judgment or review has been preferred against this judgment till date. So the judgment has now attained its finality, my lord.
Yes.
Your
What do you want to
Lordship,
submit?
I'm appearing on behalf of Miss Mary. She's on leave. Maybe.
No, but now see, Mr. Victor is rightly submitted. The case is of 2023. The contempt itself is of 2023. And your compliance was for within 6 months. That has already been lapsed.
Your Lordship,
And obviously there is no appeal, nothing is there, so it had already received finality.
Your Lordship, I cannot take up the matter because I don't have any instructions from Miss Mary. So can this matter be taken at least after 2 weeks so that we can receive
She is on
instructions?
leave for 2 weeks or what?
Yes, she's on leave till 24th of April.
24th of April.
Yes.
Yes, Mr. Victor, most probably he may not be in a position. So we are not giving any order on IA for extension of time. Let the matter be accordingly listed. As his submission, she is not here. Most probably he's at the leave note also, no?
Yes, Your Lordship.
But think of it, what Mr. Victor has submitted, because now, see, if that be the question, then obviously it will be a matter of directly a contempt.
Yes, Your Lordship, I will.
Since
ask
24,
for
you
her
have not taken
instructions.
anything, any steps after filing your affidavit. You cannot sit like this way, no?
Sir.
How many petitioners are as a whole there?
My lord, the incident case has been filed on association capacity, and it consists of more than 1,000 members who are waiting for the due consideration of
Regularization.
the judgment. And my lord, my learned friend, I understand her difficulty that she has filed a leave application till 24th of April, from 17/3 to 24th of April. But if I may say so, my lord, it's between the contenders and the court, my lord, after all. So if some arrangement or otherwise can be done.
Arrangement means? Arrangement in what kind of arrangement?
Engaging the different counsel or otherwise, my lord.
You can talk in that way
Your Lordship,
also.
I'll take instructions from Miss Mary.
If some other counsel can be engaged, or if she agrees with that. Otherwise, I'm not saying from the court side, we are not on that. But 24th April is still 25, 26 days are yet to come. Let's wait for 24, 25 days otherwise, Mr. Victor, because
Yes,
it may
please,
not
ma'am.
be a so good approach if he engages in other counsel at this stage, because she has given leave note. There may be some reason, I don't know. let's see otherwise. 9 to say IA হে IA হয় কিন্তু এইটোত ইহঁতে আছে আপুনি লিখিব এইটোত লিখক third Mr. Victor L. Ratte, the learned counsel for the petitioner, and also heard Mr. So-and-so appearing on behalf of MS Medi for the state respondent number 1, 3, 4, 7 and 11. Full stop. Next paralegal, this contempt has been filed by the respondents seeking some more time for their compliance of the order. Full stop. In view of, in that context, Mr. Victor submitted that the case is pending since 2023. The contempt case is pending since 2023. And after filing of the affidavit by the state respondents in the year 2024, no steps has been taken till date. Full stop. Accordingly, he raised objection. However, it is submitted by Mr. So-and-so, the learned counsel appearing for MS Medi, that due to her some personal inconvenience, she is in leave and hence paid another date for the same. In view of this, considering the submission made by learned counsel for the respondent, let the matter be listed. So she is on leave till 24.
24
So
of April.
give
yes.
us a fixed date so that matter can be heard and decided.
Yes, Your Lordship.
24 of what is can be date? Fixed date can be
Friday.
28th of April.
28th of April. Exactly on
Yes, Your
28th of April, go back for the hearing on that.
Yes, Your Lordship.
28th of April. And now see, by that time, if you can take any steps in that regard, just you can submit the compliance report also for appraisal of the court also, if anything has been done.
Yes, Your Lordship.
Simply extension may not serve your purpose. So you can submit if any steps from your side has already been taken during that period. So up to 28, it will be almost 28, 29 days will be in your hand. So by that time, if there is any progress, anything is there, then it can be submitted before the court
Yes, Your Lordship.
for court consideration. Okay.
My lord, let that be on record that to submit the status report. Let that be on record in view of the long pendency of the case, my lord.
This can I have already dictated. Your submission I have already dictated. It says after 24 they have not taken any steps. These
Yes,
things
madam.
I have already dictated.
Let it be on record that the respondents' counsel shall make submission on the status report.
Yes, in the next date of listing, the learned counsel for the respondent may also submit on the present status report or to apprise the court if any steps has been taken for compliance of the order till date.
Highly obliged.
Duly obliged, Your Lordship.
Item number 10.
One IA is there.
Your Lordship, yes.
Yes, what is this?
This is, we have filed a cross objection. And
13 days delay.
yes, in filing the cross objection.
Yes, do you have any objection?
Yes, my lord, if we may be given 2 weeks time to file a written objection.
13 days only.
Yes, my lord, but anyway, if we may be given a chance to file our WO.
That too for cross objection, I think, na?
Yes, my lord.
Filing cross objection, there is 13 days delay. That much only. Okay, then if you want to file any, I see which will be heard Mr. A.R. Malhotra, the learned counsel for the petition. And আসলে হেৰি হে তাৰে হয় আৰএফএটো কৰিছে এওঁলোকেহে যেনেকৈ মিলাব আৰএফএটোত এওঁলোক হেৰি ৰেছপণ্ডেণ্ট আৰু তেনেকৈ মিলাই দিলে হ'ব so and so full stop and also heard MS so and so appearing for the respondent সিফালে appellant তেওঁলোক so and so this interlocutory application has been filed for under section 5 of the Limitation Act for prolonging delay of 13 days in filing the connected cross objection in RFA 1/2026 against the judgment which has been filed against the judgment and order dated 30/10/2025 and decreed order and judgment decree dated so and so by the learned civil judge senior division number 4 Aizawl judicial district Aizawl in civil suit number 23/2017. Next for MS so and so the learned counsel appearing for the respondent appellant submitted that they need some more time to file their objection against the present petition for condemnation. How many weeks you need? Any fixed date you want? How many weeks?
2 weeks, my lord, if possible.
2 weeks.
Yes, my lord.
2 weeks of surrender this day.
20th of April.
20?
Yes, my lord.
20th of April. Enabling the petitioner at the respondent side to file the written objection if any. You can file your written objection or next date if suppose in some reason written objection is not, you can submit orally also, verbally also, no issue. You can submit.
Item number 11.
My lord, in this matter, I have just received the IA, a copy of the IA.
It will be connected as well. Yes.
My lord, in this matter, one IA has been filed. I have just received a copy, my lord. So I may be given.
Why IA is for what? Why?
For staying the operation of judgment and order.
For stay.
For staying the operation of order dated 6 March 2026. Because in this, in the order, the executive court had issued another attachment order, and earlier the executing court had passed an order dated 30/10/2025
Though
regarding
that
the
order
local
was
case.
passed in execution case number 209.
Yes, my lord.
Yes, true. Yes, 209 of 2025, and the learned executing court had passed an order dated 30/10/2025 regarding locanque of the of my residential building, and another order dated 21/11/2025 regarding the position of the LSC. These two orders has been challenged in this court. Then thereafter that the learned executing court had passed another order regarding the attachment of the LSC. Just to state the operation of the order
My
of
lord,
attachment.
if my landed friend is going to press on the IA before that, my lord, if I lost him, may kindly see page number 10 of the IA, the executing court order, my lord. IA number 60 of 2026, my lord.
Yes, yes.
If lost him, may kindly go through the order, my lord. If I may read, my lord.
Yes.
Yes, yes, my lord. This is an execution case number 29 of 2025 submitted by the decree holder against judgment debtor for executing the decree dated 12/9/2022 in civil suit number 45 of 2014. Number 2, my lord. In the decree dated 12/9/2022, it was held and decreed that the plaintiff, herein the decree holder, is the rightful owner of the landed property covered by LSC number located Chaltang, and the defendant, herein the judgment debtor, was ordered to hand over the suit land for peaceful possession of the plaintiff within 3 months of the order. That order is in 2022, my lord, in the civil suit. And then, my lord, on 25/7/2024, an agreement was executed between the parties wherein the judgment debtor agreed to pay 50 lakhs to the decree holder before 20/10/2024. In default of payment, the judgment debtor agreed to vacate her residential building located at the aforesaid LSC and hand over the same to the decree holder. In pursuance of the said agreement, the judgment debtor had paid rupees 20 lakhs to the decree holder, and outstanding amount of 30 lakhs is left unpaid by the judgment debtor. Landed counsel for the judgment debtor had prayed time for making payment on a number of court dates. Hence, an ample opportunity were given to the judgment debtor to arrange the outstanding amount. However, there was no positive action on the part of the judgment debtor. Today is fixed for report as on the last court date, the learned counsel for the judgment debtor had prayed for 1 week to arrange parts of the outstanding amount. However, yet again, there is no positive result on the part of the judgment debtor. In the meantime, learned counsel for the decree holder submits list of property and pray to attach the aforesaid LSC. Peruse and heard both the learned counsel for the parties. The prayer of the learned counsel for the decree holder is allowed. Thus, the OC Bongkon PS is hereby directed to attest the land and property covered by LSC, which is now in the custody of the decree holder, and submit to the court along with its report. That is the order which was imputed in the IA, my lord. So, my lord, it was not the case of the applicant that no opportunity was given. A lot of opportunity was given by the court, and in fact, the court was going based on their submission many times, my lord. However, since they did not make any payment in spite of several chances, this order was passed, my lord.
My lord, what I am submitting in this IA is during the pendency of the FAO number 11th of 2025, the learned executing court had passed another impinge order regarding the attachment of my property. Then, if the learned executing court had attached my property which is disputed, this FAO which is submitted in this court will become infructuous and it will become causing irreparable injustice for my client. Because of that, I'm praying to pass an interim order during the pendency of this application.
In FAO, you are challenging which order?
Look and key.
That was already infructuous, my lord.
It is not infructuous, my lord.
Since it was not carried out, it was already infructuous.
It is look and key. Regarding the look and key.
FAO, which order you have challenged?
I'm challenging order dated 30/10/2025. It is regarding lock and key, and order dated 21/11/2025
order of
regarding
lock
the
and key
position of
building.
the LLC. Yeah, it is still pending in this court. And if the learned
But why the court, as you have now read the order,
yes, ma'am.
The order passed by the court on 6/3/2026, whereby in this case, the judgment itself, it is stated that hereby directed to attach the land and properties covered by so and so.
Yes,
In bracket, this is which is now in custody of the decree holder. So land is still in your custody of the decree holder.
The land pass is in the custody and the possession is in the custody of the applicant, my lord.
So then why
The
court
mutation-
had written, why court there is in bracket, you just
Yes.
see the bracket, which is now in custody of the decree holder. That means?
The mutation has already been done, my lord.
No, custody is different thing, na?
Yes,
It is
madam.
written that custody is in the decree holder.
Yes.
So now at present the custody in which custody now? The land is
The land is
under whose possession now?
occupied by the
Judgment debtor.
judgment debtor, yes, my lord, at present.
So the land which you have been occupied by you, it was ordered at 30/10 that it has to be under lock and key.
lock and key, and the
Yes, in
order
that case, do I
dated
want to submit anything?
My lord, at this stage, since I have just received copy,
Okay, you
I
need
need
some time.
some time for submission of written objection, my lord.
Okay.
my lord. In the
And
meantime,
on the next day, the interim order may be taken up, my lord.
Lordship, day after tomorrow is the next court date for submission of the report of regarding the attachment.
Acha.
Then, if it is not stayed, then this FAO will become infructuous.
Now she has that point only. In that case, what do you want to submit? I mean, what is there? The order of 30/10 has been under challenge, where the order of lock and key was passed over this that property, isn't it?
Yes, ma'am. Yes, my lord.
So now, if the entire property is in supposed custody of there, and they have challenged the order of 30/10
Yes.
under the FAO.
Yes.
So in that case, suppose this order has been attached or this lock and key order, whatever is there,
Yes.
In that case, the purpose of filing the FAO may be frustrated.
Yes.
So let the matter be stayed and you can, dispose of the FAO at the earliest
Yes,
opportunity. Will do.
Yes, my lord.
Will pass simply order of stay till
Yes, yes.
or maybe till next date of listing.
Next date, we'll
That
submit.
can
Yes,
also
yes.
be done.
Yes, my lord.
Next date of listing of FAO, the matter will be stayed.
Yes.
And as soon as the FAO is heard and decided, automatically there will be an order.
Yes.
Okay?
Okay.
Yes, my lord. You right? Heard IA in IA. IA Civil 60 of 2026. Heard MS
Jacinta Zotanmoya.
J. Jodhampui, the learned counsel for the applicant appellant. And also heard
H. Zaudin Saha.
H. Joding Sa, the learned counsel appearing for the respondent. And this is an application under Order 41, Rule 5 CPC, read with Section 151 CPC, paying for stay of operation of the impugned order dated 6/3/2026, passed by the Court of Civil Justice Senior Division, number 3, Aizawl, Judicial District, Aizawl, in connection with execution case number 209/2025. Full stop. Next para, it is submitted by MS so-and-so, the learned counsel for the applicant appellant, that the FAO is been pending before this court against the order dated 30/10/2025 and dated 21/11/2025, passed by Court of Civil Justice Senior Division number 3, Aizawl, in Judicial District of the Aizawl, in execution number 209/2025, whereby the order of lock and key of the building standing within LSC number Aizawl 205/1987, wherein the applicant is residing, has been passed. Full stop. Chief Server is submitted by through the present application. She prayed for stay of the execution of order dated 603/2026, passed by the learned trial court below, and the next date is fixed on
1st April.
1st of April 2026. And if any stay order is not granted at this stage, the order will be executed, and in that case, the purpose of filing the connected FAO will become infructuous. Full stop. Next para. In that context, Mr. H. Joding Singha submitted that he have received the copy of the application today of the court, and from the order dated 6/3/2026 itself, it is seen that the order for attachment had to be passed, as the judgment debtor did not comply with the order of payment of 50 lakhs, and after payment of rupees 20 lakhs in one installment, the remaining amount was not paid by the judgment debtor, in spite of several chances given to the present applicant, for which the order had to be passed, and hence is submitted that it may not be stayed at this stage. Full stop. Next para. Considering the submission made by learned counsel for both sides and overall aspects of the case, it is seen that if the order dated 6/3/2026 is executed and the disputed property is already attached, the very purpose of filing, the very purpose of the connected FAO number 11/2025 will become infructuous, in considering this aspect of the case and also for the ends of justice, let the let the order dated 6 so and so 2026 passed by the Court of Civil Judge Senior Division number 3 as all be stayed and the execution of the order execution of the order dated so be stayed till the disposal of the connected appeal. With the above observation, the present I stands disposed of. Have full stop expire, yes, however, the endeavor shall be made to dispose of the connected FAO number 11/2025 in the admission stage itself. In FAO 11/2025, you write hard so and so. List the matter. It can be listed in admission column otherwise.
Yes, my lord.
List the matter in admission column when?
Then
Just
9
give us
April.
a short date.
9 April. 9 of April.
My lord, regarding the
Next week, madam.
9th of April.
Yes.
My lord, regarding the IA number 222 of 2025 is also stay.
That was already not carried out, my lord. That was not carried out.
The
2022 is regarding lock and key.
look and key, and may this matter also be stayed.
It is state only.
Yes.
What to do? It's already state. FAO, we write FAO. Hard so and so. List the matter on 9/4/2026 in admission column, and endeavor shall be made to dispose of the matter in the admission column itself. List a column.
Much obliged.
Much obliged.
Anyone for hearing?
This one is disposed of only IA 60. No? IA 60 is disposed of. Part 2, anyone? Anything? Part 2 one? Yes, someone is there. Yes, any part 2 matter, anything for hearing? No. No, it's okay then. We have another matter at 12 from our principal seat. No, otherwise, you want to any submission? Yes.
No, my lord. I have item number 5 of hearing, my lord, but the other side are not here.
Item number 5. Yes, it is hearing RFA. Yes.
The respondents counsel are not available today.
Let it not be pressed. Here, tomorrow is a holiday, na here? For Mahavir Jayanti. And principal seat is open day.